I'm Cynthia Rowland, and this is episode 132 of EO Radio Show. In episode 131, I talked about my general form grant agreement provisions and best practices for basic grant agreements that I recommend for grants from public charities and private foundations. This week, I want to cover some special issues and important provisions that often come up and deserve careful drafting considerations. In this episode, I'll cover my thoughts on matching grant conditions, intellectual property rights, recoverable grants, and indemnification and risk management issues. Welcome to the EO Radio Show, your nonprofit legal resource. Brought to you by the Exempt Organizations Group at Farella, Braun & Martel. My name is Cynthia Rowland, and I'm a partner at Farella. I'm a business and tax lawyer with more than 30 years of experience advising clients on nonprofit and charity law. Through this podcast, our lawyers and guests will discuss a range of legal and business issues impacting the nonprofit world because we understand you work hard every day to make your community a better place to live and do business. Many of our programs focus on the basics, and at times we'll do a deep dive into narrow and complicated legal issues. Again, welcome to the EO Radio Show. We're glad you're here. So let's talk about grant agreements between charitable organizations. In episode 131, I talked about general support grants to public charities, project-specific grants made by private foundations to domestic operating charities, special concerns for endowment grants, and some considerations about naming rights associated with significant gifts. I'm going to assume throughout this episode that the grant-making charity, which I'll refer to as the grantor, is organized in the United States and is recognized by the IRS as an organization described in 501c3. Let's also assume today that the grantor annually has an independent audit by a CPA firm and so is attentive to internal procedures that follow typical grant review and approval procedures. So hopefully you've listened to 131 already to go over all the customary provisions. And today we're just going to dive deeper into some areas that aren't in every grant agreement, but when they are, they deserve a little extra attention. So first up, matching grant provisions. We've all seen those solicitations where a charity says, give now, you'll be matched 1-for-1, or you'll be matched by a donor, so your gift is twice as much. And those are really great. I think they come across very favorably to the potential donors. So looking at this from the perspective of the grantor foundation that is going to provide the match, so the first step for the grantor organization that will be matching the gifts is usually to talk with a development officer at the grantee. That way, the two sides can be very clear on all the potential provisions for the grant agreement before someone starts committing it to the actual grant agreement. Sometimes if it's a particularly complicated grant provision or terminology, I might actually start with a term sheet that just talks about the specific understanding of what the match will be for, and then hand that off to the legal counsel or the grant drafting team to put it into the agreement. Sometimes these matching grants are particularly useful in the context of a capital campaign by the grantee or the launch of a specific project. So that's question number one, is what does the grant specifically go for? Is the match for general support grants? Is it only for gifts that are to a particular capital campaign or gifts to a specific project? And the more specific the provision in the grant agreement is, the better. Second item there is the measurement term. How long does the organization, the grantee, have to raise the matching grants? And sometimes I've seen grantors that really want to match only large amounts and only if they're brought in a relatively short time period. Other times it's appropriate to have the match term over a longer time period. So that's an important provision to get clarity with the grantee on. Third item is how exactly is the match going to work? Is it $1 for every single dollar? Or is it only intended to match big grants, thereby trying to stimulate major donor gifts? Is it 2-for-1? Is it 3-for-1? It can be as creative and as complicated as the two organizations wish. Next, really important consideration is what counts towards the match. Do pledges count, or is it only dollars in the door? Do planned gifts count? That is, are you trying to stimulate gifts made through estate plans or through charitable remainder trusts and the like? And if not, usually those sorts of things aren't included. If not, be very specific up front with the development officer and the grantee. What about assets other than cash? Will gifts of appreciated property count towards the match? And if so, how will they be valued? And then finally, things like gift annuities. Those can present particularly difficult problems because if you count a gift annuity, the actual amount that ends up in the charity's hands, in the grantee's hands may not be known for years. So it's best to be very clear with the development officer about what sorts of gifts will count towards the match. Similarly, I've seen some matching grant campaigns where the big idea was to bring in new donors. If the matching grant only goes for new donors brought in the door, that's going to be a different sort of outreach from the grantee to try to reach the match numbers. And then down to some details about the reports from the grantee. How frequent do you want the match amount reported? Or do you only want a report at the end of the term that says, this is the amount of qualifying grants made, and please send the match by such and such a date? Other grantors want to see more frequent reports to know how things are proceeding, particularly if the grant term is over a very long time period. And then finally, is the match going to be, as I mentioned earlier, dollar for dollar, or will it be in round numbers with somewhat of cliffs that if you raise, the match will be made only in $10,000 increments, as an example. If they raise $10,001, the match is only for $10,000. They've got to get to 20 before they get another match. So there's different reasons to have these kinds of provisions in the matching grant terms. One can keep it very simple, or one can get as complicated as you like. So those are my thoughts on matching grants. Moving on to intellectual property rights. This comes up a lot in grants to universities, research institutions, sometimes to organizations that are doing just surveys, or the grant that is intended to support a particular project that will result in a written deliverable. So oftentimes there's no substitution for getting IP counsel, intellectual property lawyers involved to make sure that the language in the grant agreement says what you as the grantor want it to say. Other times it's just a matter of reading through what the grantee proposes and making sure that it meets your expectations as the grantor. So typically, the grantee wants to retain its own IP that it developed before the project that's funded from the grant, and it wants to own and control the intellectual property that arises from the grant. So you'll typically see a provision that says that the grantor understands and acknowledges that the grantee's knowledge, experience, and expertise in performing the work and analysis of the type to be provided under the agreement has been acquired prior to the grant period. And so that background intellectual property remains owned by the grantee, and that the grantee can control all of that background intellectual property, and the grantor has no rights in that background material. However, for the materials developed with the grant proceeds, there's often an expression of the intent of the parties that the grantee will grant to the grantor a non-exclusive license to use the work product from the grant. And this provision typically includes notice requirements that the grantee will tell the grantor of any work product developed with the grant proceeds, and will provide information about any patent applications filed or any copyrights filed and things of that nature. The grantee is usually the party responsible with all of the IP ownership requirements. That is, that they will file with the Patent Trademark Office or obtain copyright registrations and the like for the materials developed with the grant proceeds. But then the critical part there for most grantors in this type of a situation is that they want the widest possible distribution of the grant work product, and they want to ensure that it furthers charitable purposes and benefits the public. And so it will often want to see a specific provision in the grant agreement that provides a grant to the grantor of a non-exclusive, transferable, perpetual, irrevocable, royalty-free, paid-up worldwide license to use, display, perform, reproduce, publish, copy, and distribute for non-commercial purposes the work product from the grant. Now, that's a lot of what some people would call word salad, but each of those words means something to an IP lawyer. So don't be surprised if you see that in a grant agreement with a research institution where the grantor wants to have some rights to use and make sure that the grant work product actually gets out into the public and it achieves the charitable purpose intended. So when in doubt with this IP language, it's definitely not a do-it-yourself project unless the grantor team has a knowledgeable intellectual property lawyer on staff. So I would strongly encourage, if the IP work product of the grant is important, have an IP lawyer look at it from the grantor's perspective to make sure that the grant agreement says what you want it to say. All right, next topic. I want to talk a little bit about recoverable grants. Now, these are rarely used, but they definitely have a place in the ecosystem of grant agreements. Typically, a recoverable grant is used when the grantor is funding the development of a product that will generate some sort of economic return. And the philosophy behind a recoverable grant is often that the grantor foundation can take more risks with grants for projects that can be economically viable if they get a return of the funds so that they can recycle the proceeds from their grant-making program. And this is closely related to program-related investing, but the difference here is that a grant is not an investment. It's accounted by the grantor institution as a charitable gift, and the grant is recoverable. That is, the grantee returns all or a portion, or sometimes all plus earnings on grant proceeds that are given for a particular purpose that may actually generate returns. So your recoverable grant agreement will include all of the typical things that we talked about in the previous episode in 131, but then we'll also have several sections on the obligations of the grantee with respect to repayment to the grantor. So there will be a section on repayment obligations that will spell out in detail the measurement metrics for what will trigger a repayment obligation. So in this section, we'll usually have a carefully drafted definition of gross revenue. What kinds of returns will be accounted for when measuring the portion of the grant that needs to be repaid to the grantor? Typically, funds received by the grantee from equity or debt securities don't count towards the required repayment on the recoverable grant. And of course, gross proceeds of the grantee that are unrelated to the funded project. So sometimes the grant agreement, the recoverable grant, also requires something like a running royalty or interest payments that relate to gross revenue received by the grantee or its affiliates or subsidiaries. You also want to be clear that this is whether the recoverable amount applies only to the grantee or to grantee's affiliates if it's sublicenses. So sometimes these things can get quite complicated, and you'll want to be clear about that. Next, the payment due dates. It can be quarterly, it can be annually, a particular threshold is met. But in any event, the grant agreement typically requires very regular grantee reports that certify to the grantor the amount of gross revenue that counts towards the repayment obligation during the prior accounting period. And let's see, what else do we want to say about recoverable grant agreements? In addition to notice about revenue earned that might count towards the repayment, there's also typically provisions that require notice of major transactions that require written consent of the grantor, such as a sale of all or substantially all of the business or things like that, where the assets that generate the recovery might be sold elsewhere. And that notice gives the grantor the opportunity to either insist on continuing obligation to repay the grant or to agree that charitable objectives have been achieved and so repayment is not necessary. So that's kind of an overview of recoverable grants. Again, they can be very complicated. On the other hand, sometimes they're relatively simple. They're just, if the project is monetized, then the grantee repays the grantor for its grant funds that enabled the launch of a successful venture. So finally, a couple of other interesting provisions that are sometimes, I would say in most grant agreements, these don't appear, but they do come into play when the grantor is funding a program that has some degree of risk associated with it. Maybe a grant that involves building a building or a grant that involves a particular kind of service to a vulnerable population. Grantor organizations really want to be at arm's length from those activities. So the expectation is that the grantee will take on the risk of operating the program. So in those circumstances, you'll typically see two risk management tools and one dispute resolution paragraph. And dispute resolution actually can apply to any sort of grant agreement, but it's definitely something that comes up in a grant where there's a perception of risk that the grantor wants the grantee to stand behind. So anyway, the indemnity provisions can be 5 lines like the one I'm looking at, or they can be several pages. That's rare in a grant agreement that I'll see the very long version of an indemnification provision that spells out notice requirements and who indemnifies who for what. And, sometimes it's a mutual indemnity. But in most grant agreements, if you see indemnity at all, it's a very simple provision that provides that the grantee, since the grantee is in control of the activities, that the grantee will indemnify, defend, and hold harmless the grantor. And it's important to also include the grantor's officers, directors, employees, and agents from all liability, loss, damage, cost, blah, blah, blah. Again, that's legal word salad, but it's important. Caused by or arising out of a breach of the grantee of its obligations under the agreement or the grantee's actions in performing the project that's funded with the grant proceeds. So again, indemnity provisions can be very lengthy and very specific, but be very careful to read that and think it through. I can't tell you how many times I've seen the indemnitor and indemnity language mixed up where it's exactly the opposite of what the parties intended. And the final provision I want to talk about is the requirement for insurance. Again, in most grant agreements, the grantor doesn't really care what insurance the grantee is carrying. But in others, particularly if it's a grantee that has a lot of active programs and where a significant injury or problem could really affect the grantee's ability to perform, as a grantor, you're actually doing a service to the grantee to put a provision in there or make sure there is a provision that requires the grantee to obtain appropriate insurance given the scope of their activities and the types of things that they're doing. And sometimes you ask for an actual certificate of insurance and proof that they continue to keep that insurance in force during the term of the grant. So that's a lot. I've covered quite a few special provisions. I hope it's helpful. That's all I'm going to cover in this episode, but be sure to check out the show notes for links to other episodes relevant to grant making. And you can find all of the prior episodes on our YouTube channel. There are a number of playlists, so enjoy browsing to find topics of interest to your organization. I'm Cynthia Rowland, and you've been listening to EO Radio Show, your nonprofit legal resource, brought to you by the Exempt Organizations Group at Farella, Braun & Martel. If you have suggestions for topics that you would like for us to discuss, please email us at eoradioshow@fbm.com. That's eoradioshow@fbm.com. Thank you for joining me. Until next time, make a difference.